Welcome to the Am I Free to Go podcast, where the Constitution isn't just paper, it's ammo. I'm your host, Soundrone with Soundbite News Media. And here, we don't just talk about your rights, we lock, load, and defend them. We expose censorship, spotlight real amendment battles, and bring you the stories the mainstream's too scared to touch. So, whether you're behind a mic, behind a badge, or behind enemy lines on social media, this is your front line in the fight for free speech. Strap in, speak up, and never ask permission, because around here, we know the truth. You are free to go. Episode 002, Reasonable Articulable Suspicion. Today we look at reasonable articulable suspicion and probable cause in U.S. law. Reasonable suspicion allows police to briefly stop and possibly frisk someone based on specific articulable facts suggesting potential criminal activity, such as in a Terry stop. Probable cause requires stronger evidence and is needed for identifying arrests or searches, including those with warrants, and refusal to cooperate does not meet this standard, even in the event a 911 call was made.
Welcome to the Deep Dive. We've got something really essential to dig into today. It was requested by a listener, actually.
Oh, really? What's the topic?
Someone wanted to understand the legal standards police use. You know, when they stop people, ask questions, maybe do a search.
Ah, okay. Big topic.
Yeah, and crucially, what rights you have during those encounters.
Right, that's fundamental stuff. It really gets to the balance between, police authority and individual liberty. It's not just theory, it's practical.
Totally. And we've gathered quite a bit of material stuff from law enforcement groups, legal expert analysis, practical guides from the ACLU, and even like a discussion between officers and lawyers online.
Oh, interesting. So different angles, the view from the street, the courts, the rights perspective.
Exactly. So the mission today is to sort of cut through the legal jargon, right? Give you a clear picture of reasonable suspicion, probable cause.
Yeah, what they actually mean.
And show how they work in real life, using examples from these sources, and give you some tips on handling things if you're stopped.
Sounds good. Where should we jump in?
Let's start right at the foundation. The two big legal standards that keep coming up: reasonable suspicion and probable cause.
Okay, bedrock.
They both tie back to the Fourth Amendment, the one protecting against unreasonable searches and seizures. Basically, police need a justification, a reason to interfere with that right.
And these standards define how good that reason needs to be. And they're different levels, right?
Exactly. Reasonable suspicion, that's the lower bar. It's got to be more than just a hunch, though. The sources stress that. It can't be an unarticulated hunch, as the courts say.
Right. It needs specific and articulable facts. The officer has to be able to point to concrete things, what they saw, heard, whatever, and draw rational conclusions from those facts.
So it's not just a gut feeling. It's a feeling backed by facts you can actually explain. How do courts decide if the facts are enough?
They use a reasonable person or reasonable officer standard. Basically, would someone reasonable, looking at the same situation, suspect that maybe some criminal activity is afoot?
Okay, reasonable suspicion, specific facts, reasonable person's standard, lower level. Got it. So, probable cause. That sounds, more significant.
It is definitely the higher standard. This is what's needed for, say, an arrest or getting a search warrant.
Right.
It means a reasonable person would believe that a crime was, is, or is about to be committed. Or, as one source puts it, reasonable grounds to think a crime happened and this specific person did it. It's about likelihood, not certainty.
So if you picture it like steps, bottom step is just a hunch.
Yeah, a gut feeling. Not enough legally.
Then you step up to reasonable suspicion facts make a reasonable person suspect something criminal. That allows for a brief stop, right, to check it out.
Correct. A limited stop to investigate.
And if that investigation turns up enough for a reasonable person to think a crime is probable, then you hit probable cause.
And that allows for an arrest or a more intrusive search.
And then way up top, for court conviction, that's proof beyond a reasonable doubt.
Exactly. Seeing those levels helps clarify what police can do based on the information they have.
Okay, let's zoom in on that first real step. Reasonable suspicion. What exactly can an officer do with just that?
Well, reasonable suspicion is the legal basis for what's called a brief investigative detention. Most people know it as a Terry stop, from the Supreme Court case Terry v. Ohio.
And the whole idea of a Terry stop is just short term. hold someone briefly because you suspect a crime, investigate quickly.
That's the gist. It's meant to be limited, just long enough to confirm or dispel that initial suspicion. If they find enough for probable cause during the stop, okay, an arrest might happen. If not,
They have to let you go.
right.
And Terry v. Ohio also gives us the frisk, which people often mix up with a full search.
Yeah, that's a really important distinction. A frisk is technically a search under the Fourth Amendment, but it's very limited. It's specifically a pat-down for weapons.
Okay.
And an officer can only do it if, after they've already lawfully stopped you based on reasonable suspicion of criminal activity, they then develop another reasonable suspicion that you are currently armed and dangerous.
So it's like 2 layers of reasonable suspicion needed. One for the stop itself, and a second one specifically about being armed to justify the pat-down.
That's often how it works in practice, yeah. The frisk is really about officer safety during that temporary stop.
Makes sense. So what kind of specific and articulable facts actually build up to reasonable suspicion? What counts? The sources list quite a few things under the totality of the circumstances.
Right. It's usually a mix of things, not just one isolated factor. The sources mention stuff like the time of day, is it unusual for what's happening? Being somewhere unexpected.
Like a closed business area at 3 a.m.
Yeah, something like that. Or being in a known high crime area. Though the sources are really clear, and courts agree, just being in a rough neighborhood isn't enough by itself. Absolutely not.
Okay, what else? Weird clothes or actions.
Yeah, unusual behavior, something that just seems off. Also, sensory stuff, smelling something illegal, maybe hearing a gun being racked. Information from a credible witness is big.
Can the officer's own knowledge count? Like if they know someone has a history.
Sometimes, yeah, an officer's knowledge of a suspect's past can factor in, but courts look at that very carefully. Even things you say during the stop could add to the suspicion.
But just as importantly, what doesn't count on its own?
Crucial point. A hunch, like we said, never enough. Just refusing to answer questions if you're not arrested, generally no. Saying, I don't consent to a search they ask you to volunteer for, also usually not grounds for detention itself.
What about seeming nervous?
Nervousness or evasive behavior, officers often note it, but courts say it's usually not enough by itself. I mean, lots of innocent people get nervous around police, right?
Yeah.
And again, just being in a high crime area or simply not wanting to chat with the police isn't enough for reasonable suspicion.
This seems like where that People v. Flores case mentioned in one source really fits in. It shows how courts weigh that totality.
Oh yeah, the Flores case is a great example of that line. So Flores was spotted at night, high crime area, sees the police, ducks behind a car, stays bent over, looks like he's messing with something near his shoe.
Okay, I could see how that might look suspicious to an officer. Hiding, fiddling. And the lower courts agreed at first, right? Said it was odd behavior, enough for a stop.
They did. But the California Supreme Court looked closer at the specifics. They pointed out, look, he didn't run away full tilt, what courts call headlong flight, which is a much stronger indicator.
Oh, okay.
Flores' actions, yeah, they were odd, but they mostly just suggested he didn't want to interact with the police. It wasn't clearly criminal behavior. The officers didn't see him hide anything specific. No crime reported right there.
So his behavior could have innocent explanations.
Exactly. The court basically said the officer's feelings seemed more like a hunch based on experience rather than objective facts pointing strongly to crime. It's a good reminder that intuition matters, but the legal standard demands those articulable facts.
Okay, let's shift focus slightly. Reasonable suspicion is huge for traffic stops, isn't it? That's probably how most people encounter this.
Absolutely. To pull you over, an officer needs reasonable suspicion that someone in the car is committing, has committed, or is about to commit a crime, or simply that a traffic violation occurred.
And that violation can be tiny, like a burned out license plate light.
Yep. Any traffic infraction, even a minor equipment issue, or, barely drifting over the line, that's technically enough reasonable suspicion to justify the stop itself.
Which leads to pretextual stops. Sounds a bit tricky, but they're allowed.
They are, yeah. It means an officer can stop you for, say, that minor taillight issue, but their real reason, their primary motive, might be they suspect something bigger, like DUI or drugs. As long as the initial reason the taillight is a genuine violation, the stop is legal. They do have to address that initial reason, though.
Once they stopped you legally, how long can they keep you there?
The detention has to be reasonable in length, just long enough to investigate whatever the suspicion was about. It's very case by case. One thing the sources note is, if you cause delays, like by lying, that time might count against you. But if the delay is purely the police is doing, like, waiting an excessively long time for a drug dog, without any other reason developing that can make the continued detention unlawful.
Can they search the car based only on the reasonable suspicion that got you stopped?
Only a limited search, much like the frisk of a person. If the officer develops reasonable suspicion that the people inside are armed and dangerous, then for safety reasons, they can do a limited search of the passenger compartment just for weapons.
Passenger compartment frisk. What does that cover, generally?
Usually areas that someone inside could reasonably reach to grab a weapon, so unlocked containers in the front glove box if it's unlocked.
What about if the glove box is locked?
That's where there's some debate, even in the online discussion source we looked at. Some officers and lawyers argue maybe yes under the officer safety idea. Others think you'd probably need probable cause for something locked. But the trunk, that almost always requires probable cause or a warrant since it's not readily accessible.
Gotcha. So RS gets you stopped, maybe a limited weapon search of accessible areas. But what if, during that limited search, they feel something else?
Right. If during a lawful frisk of you or the car's passenger area, the officer feels something and it's immediately apparent just by touch that it's a weapon or illegal contraband, like drugs.
Like the plain touch idea.
Exactly. That's the term one source used. That feel can then provide the probable cause needed to go further, like doing a full search or making an arrest.
Okay, that makes sense. The limited search provides the basis for the bigger intrusion if they find something obvious. So when does it officially cross that line from just reasonable suspicion to the higher standard probable cause?
It crosses when the facts and circumstances pile up enough that a reasonable person would believe a crime is likely happening, or did happen, or is about to. That's the point where the police get significantly more authority. They can move beyond just a quick stop and frisk.
And probable cause is what's needed for warrants, right? Arrest warrants, search warrants.
Precisely. A judge needs probable cause to issue those. For a search warrant, the judge looks at everything and decides if there is a fair probability that evidence or illegal stuff will be found in that specific place.
And arresting someone without a warrant.
An officer can do that if they have probable cause to believe a crime was committed and that the person they're arresting is the one who did it. It needs to be based on reasonably trustworthy information enough for a solid, good faith belief.
We saw that interesting case mentioned, Maryland v. Pringle. It showed how probable cause might sometimes apply to more than just one person in a car.
Yeah, that's a useful illustration. In Pringle, police found drugs in a car. Nobody admitted they were theirs. The Supreme Court said the officer had probable cause to arrest everyone in the car.
Wow, really? All of them?
Yeah, the reasoning was sort of this common enterprise idea. People in a car together are often involved in the same activity. If there's contraband and no one claims it, it's reasonable to think any or all of them could possess it.
Huh. So PIC can sometimes sweep a bit wider depending on the situation, like that common enterprise concept.
It's still about the totality of circumstances, just viewed through that higher lens of probability.
Okay, so we've covered the legal yardsticks police use: reasonable suspicion, probable cause.
Yeah.
But, and this is huge, even when they have that justification, you still have constitutional rights.
Absolutely critical. And knowing what those rights are, like the ACLU source really hammers home, is maybe your best tool. It helps you stay calmer, handle things better, and hopefully not make things worse accidentally.
So let's get practical. Based on the sources, like the ACLU guide, what should you do if you're stopped on the street, not in a car?
First thing, ask, am I free to go? Get clarity on whether it's voluntary or detention. If they say yes, just leave calmly, no sudden moves.
And if they say no, you're being detained, then what?
Then you ask why. Can you tell me why you're stopping me? And then assert your right to silence. Say clearly, I want to remain silent. Remember, you can't be arrested just for staying silent, but stating it makes it official.
What about searches, if they ask to search you?
You state clearly, I do not consent to a search. Now, they might search anyway if they believe they have legal grounds, like RS for a weapon frisk or PC, but make your non-consent known. Huge don't, though. Never run, never physically resist if they do search.
Yeah, physical resistance is a bad idea. Any other key don'ts for street stops?
Don't be disrespectful. Even if you feel wronged, arguing or being rude can escalate things, maybe even lead to other charges. Don't lie. Lying to police is a crime itself. And just be aware, police are allowed to lie or bluff during questioning. That's a tactic they can use.
Okay, different scenario. stopped in your car. What's the advice there?
If you're driving, DO, show your license, registration, insurance when they ask. Keep your hands visible on the wheel is good. And maybe announce movements like, okay, I'm reaching into the glove box for my registration now.
Search consent, same advice.
Same advice. DO, state clearly, I do not consent to a search. Protects your rights if they lack justification. But again, don't physically resist if they proceed based on what they believe is legal cause.
What about getting a ticket?
DO, sign the ticket if asked. You're just acknowledging you received it, not admitting guilt. Don't refuse to sign. That can actually lead to arrest in many places.
DUI tests, sobriety tests.
The sources generally advise you, DO, take a requested chemical test, like a breathalyzer. Refusing often triggers an automatic driver's license suspension, separate from any criminal case outcome.
Anything about the car itself?
Yeah, practical tip. Try to keep your car interior relatively clean and clear. Less stuff lying around means fewer things that could potentially be misinterpreted or give an officer a reason to look closer.
Good point. And if you are arrested from your car?
DO, ask if you can arrange for someone to pick up the car, or if it can be parked safely. Might save you towing and impound fees.
Okay, last scenario. You're arrested and taken to the station. What now?
DO, give your name and basic ID info, but nothing else about the incident.
This is where invoking rights formally is super important.
Absolutely. Do state clearly and repeatedly if necessary, I want to remain silent and I want to talk to a lawyer. Those are the magic words. Questioning should stop then. Don't try to explain or tell your side of the story before you speak to that lawyer.
And you get phone calls.
Yes, do make sure you get them. The source mentions specifics, often 3 calls within a few hours of booking, maybe more if you need to arrange childcare. Memorize important numbers.
Good tip.
And do assume police are recording your calls, except the one to your lawyer. So don't talk about the details of your case on those calls.
Final don'ts after arrest.
Don't make any decisions about your case pleading guilty, talking more to police without your lawyer's advice, and don't discuss immigration or citizenship status with anyone but your lawyer.
Wow, okay, so this deep dive really maps out the landscape, the standards police operate under, and the rights you hold on to.
Yeah, understanding that difference between, a hunch, reasonable suspicion, and probable cause, it's powerful. It shows you the boundaries of police power. It helps you see when their actions likely have a legal basis and maybe when they don't.
And then pairing that legal knowledge with the practical how-to, the phrases to use, the actions to take or avoid, like from the ACLU guide that gives you real tools for handling what can be a really stressful situation.
It's really about being informed and prepared, which honestly helps everyone involved by making things clearer and respecting those constitutional lines.
So, wrapping up this look at reasonable suspicion, probable cause, and your rights. It's clear there's this constant balancing act, right, between keeping the public safe and protecting individual liberty.
Definitely. The rules are written down, but how they get applied on the ground really depends on the specific facts and ultimately how courts interpret those facts later on.
And that leaves us with something to think about maybe. Consider this. We heard that nervous or evasive behavior can be one factor contributing to reasonable suspicion.
Right.
So, how might someone's past negative encounters with police or just general anxiety around authority cause them to seem nervous or evasive, even if they're totally innocent? And could that understandable reaction unfairly influence an officer's perception, maybe tipping the scales towards finding reasonable suspicion where it might not otherwise exist?
That's a really crucial question. It really highlights how subjective interpreting behavior can be, even when applying these supposedly objective legal standards. Something definitely worth mulling over.
Indeed. A lot to consider there.
Thanks for tuning into the Am I Free to Go podcast. Support the show by checking out our First Amendment gear, wear your rights proudly, and help us keep creating content like this. You can also join us on Patreon for access to uncut videos, outtakes, bloopers, and exclusive audio-only episodes. Don't forget to subscribe and hit the bell across all our channels. Links are in the description. And most importantly, we love reading your comments. Drop your ideas below, and you might hear your suggestion in a future episode.